South Africans who've had their citizenship stripped under the Citizenship Act, which was implemented in 1995, can now have their citizenship retrospectively reinstated. This as the Constitutional Court ruled that the Act was inconsistent with the Constitution.
The right to citizenship is entrenched in the Bill of Rights and in terms of Section 36, cannot be infringed upon or limited without justification. Any active removal of citizenship is on the face of it an infringement that requires justification in terms of Section 36(1) of the Constitution.
The application was brought about by the Democratic Alliance Abroad when a South African who had been naturalized to be a British citizen discovered that he had relinquished his South African citizenship. The Pretoria High Court had rejected the DA's assertion that the Act deprived South Africans with a dual citizenship of their inherent South African identity.
The court further notes that Section 6(2) of the Act provides no criteria at all on how the minister's discretion is to be exercised and what its bounds are. The legislature argues that dual citizenship is permissible, subject only to ministerial discretion. This reasoning is unclear and utterly irrational. What we are left with is the bold assertion that the retention or loss of citizenship is itself a legitimate use of power. That is beyond comprehension.
The Democratic Alliance welcomed the ruling, which also included the cost of two counsel.
The previous ministers took it through all the ranks of the courts, to the Supreme Court, to the Supreme Court of Appeal, just to now today, after 10 years, finally to get surety for people living outside of South Africa or people who lost their citizenship.
Home Affairs Minister and Director General, who are respondents in this matter, were not available to comment. Offense Estimo, SABC News, Johannesburg.
In terms of Section